Hello. From time to time, we encounter a court judgment which serves as a pointed reminder to public authorities that they cannot be passive onlookers. They must act in accordance with the Mental Capacity Act, form clear, well-reasoned views on what is in the best interests of a person who lacks capacity to decide for themselves, and bring matters before the Court of Protection when required. Now, one of such case is NHS South East London Integrated Care Board. It's a long title, this one. So it's NHS South East London Integrated Care Board against JP by his litigation friend, the official solicitor, and the Royal Hospital for Neurodisability, and TP, and VP, and OP. It is a particularly sad and distressing case where JP was in a permanent vegetative state for around 9 years. Joining me today to discuss the judge's findings and particularly their wider-ranging implications is Arianna Kelly, an extremely well-regarded barrister at 39 Essex Chambers and, perhaps more importantly, counsel for NHS South East London ICB in this particular case. Arianna, thank you for joining us and welcome. Well, let's deal with the obvious question first. What was this case all about?
This case was about a man who was anonymized in the judgment as JP. He was 64 years old at the time that the case came before the court, and he was part of a large and religious family. He had grown up both in England and Jamaica and had lived in England since he was 15 years old. He had 5 children, and his family emphasized what a really very independent and active person he was, who greatly valued physical fitness. One of his daughters even mentioned that sometimes he would go for runs at night with her because he told her that it would help her to sleep. He was always on his bike. He was always off doing something in his home gym. He was just somebody who really valued his physical life very much. His family also talked about how important his faith was to him, and he regularly read the Bible and discussed his faith with his family, and in particular, his mother. He was really close with his children and his partner, and he was always described as someone who was a very active and hard worker who was always doing something or another. In January of 2016, JP very sadly had a catastrophic heart attack. He had been cycling to work and he collapsed at the roadside, during which time he suffered a hypoxic brain injury. At least 25 minutes passed before his circulation had resumed, and after initially needing to be ventilated, being unable to breathe after the heart attack, he became self-ventilating about 10 days later. However, he did not become able to eat or drink and was put on artificial nutrition and hydration. He was in a permanent vegetative state since January 2016. In April 2016, he moved to the Royal Hospital for Neurodisability in Putney. No best interest decisions were held to consider whether or not to continue artificial nutrition and hydration, and that issue wasn't looked at until 2022. This application was brought in late 2023 to consider his best interest about whether or not to continue that treatment or whether to withdraw that treatment and put him on effectively a palliative care plan that would inevitably lead to his passing away. The medical evidence was overwhelming that, particularly after 9 years of being in a permanent vegetative state, JP would not recover and had no awareness of the world around him. The evidence was also that he probably did not experience pain, though this was possible, and he was given pain relief as part of the plan in order to make sure he wasn't experiencing any if he did. His children, particularly his 3 youngest children, gave really clear and compelling evidence that he would not want to live in the way that he was living. While they were obviously very distraught about the situation that he was in, what they said is that he had talked to them many times in his life about how he would never want to live like this. And this was something actually he had specifically contemplated because his partner had sadly become very unwell several years before he had the heart attack. And he had said he would never want to live in a bedbound state. He wouldn't want to go on like that. He would want to pass away if that was what came to pass with him. He had also made similar comments to his brothers. However, other members of the family, in particular his mother and his sisters and his niece, felt that he would not want to have artificial nutrition and hydration withdrawn. They felt that he would want to go, as they saw it, naturally, and to go when God intended it. And they saw removing the artificial nutrition and hydration as an interference with what would be his natural passing at some future point in time. So this came before the court to weigh it up, and Mr. Justice Hayden found quite overwhelmingly on the evidence that JP would not have wanted to live in the way that he was living, and it was not in his best interest to continue on with artificial nutrition and hydration. So the court approved a plan to withdraw artificial nutrition and hydration, which again would inevitably lead to his passing away.
Now, the Honourable Mr. Justice Hayden was critical of several things, but particularly the delay in getting the matter before the court. Was it merely, as it were, the disagreement between the family that caused that delay, or was it something else?
So it wasn't merely the disagreement between the family. There were a number of factors which unfortunately contributed to the delay. As far as I'm aware, I don't believe there were any best interest meetings held between 2016 and 2022 to formally consider JP's best interest. In 2021, there was a case called GU, which also involved the Royal Hospital for Neurodisability, in which there were a lot of criticisms against the hospital for in relation to the care of a person who had a very similar presentation to JP. They were also in a prolonged disorder of consciousness. They were also needed artificial nutrition and hydration, and the evidence was also that they probably would not have wanted to live like this. Following that case, as part of a review that was conducted by the hospital following criticisms by the court, and I believe again, Mr. Justice Hayden in that case, JP's case was identified as one which required a best interest process to be undertaken around whether or not to continue his artificial nutrition and hydration. The hospital began that piece of work, carry out a review of his best interests, which took nearly a year in itself and involved getting in touch with a number of members of JP's family, many of whom did not live in the UK anymore. So that went from about 2022 to about 2023. By 2023, it was crystallized that there was not going to be agreement as between the family and the hospital as to what was in JP's best interest. And because the hospital is a charity rather than an NHS hospital, after they conducted their in-house best interest process, they conducted the ICB and asked the ICB to make the application to the Court of Protection. The ICB then had to conduct its own due diligence, which took a couple of months, but most notably what took some time was instructing a second opinion of JP's condition, which was going to be necessary for the court to have in order to properly consider this. So the ICB then filed the application in December 2023. The matter was also then initially listed for a hearing to be heard in March 2024, but the court adjourned it and didn't relist it until January 2025. So there were, very unfortunately, a series of things which contributed to the overall delay. The family's disagreement being one of those factors, but not really the primary factor, because the 6-year delay largely came from the fact that no one even held the best interest process in that time.
So partly due objections from the family, but mainly due problems with the process.
Mainly due problems in the process, and really people not looking at conducting a best interest decision at all, being by far the longest cause and delay within the process.
So interestingly, this appears, doesn't it, to be the third. You mentioned the GU case and Mr. Justice Hayden, but there was actually another case which Mr. Justice Hayden wasn't involved in before another judge. It's the third time we think that the Royal Hospital for Neurodisability has been criticised at quite a senior level by the courts for delays of this nature. Now, to be fair to them, they did offer an explanation to the court, as well as, of course, apologies to JP's family. Could you give us a précis of the explanation, please?
Of course, yeah. And there was the other decision of Mr. Justice Tice that you'd mentioned as well, which had only been a couple of months before our decision in the JP case. And the explanation, again, was fairly similar. And what the hospital said was that following the judgment in GU, which again was very similar facts to this case, and there are a great number of people at the Royal Hospital for Neurodisability in Putney who were in states of prolonged disorders of consciousness, there was a significant internal program within the hospital to identify patients who were in prolonged disorders of consciousness and on artificial nutrition and hydration, and to hold best interest meetings around them. From our second judgment in JP, the explanation, which is reported by the court, states that there were approximately 70 patients who were in a similar situation to JP of being both in a prolonged disorder of consciousness and receiving artificial nutrition and hydration in the nursing home aspect of the hospital, which is where JP lived. It appears for the vast majority of these people, agreement was reached as to whether or not continuing artificial nutrition and hydration was in their best interest. And what the judgment reports is that agreement couldn't be reached in 7 cases, which included JP, and that 9 people had ongoing processes, and 3 individuals sadly had passed away before the processes came to an end.
Thank you. Now, Mr. Justice Hayden also emphasised the critical role that ICBs have to play in such matters. And I think the term used was not being passive bystanders, instead focusing on the person's wishes, feelings, values, beliefs, and taking into account the views of those caring for the person and of others interested in the person's welfare. Now, in this case, of course, as you've highlighted, there was a divergence of views within the family. Some wanted JP's wishes, as expressed, to be followed. Others wanted the religious beliefs that JP followed, essentially, to be followed. What did the judge have to say about the role of family members in best interest decisions, which need to be made actually by healthcare professionals?
Well, so the first thing I'd say, and I think this is, you can see from the judgment that there were some submissions that I made on behalf of the ICB, which were not accepted by the court. But I think one point that I would make as an overarching point is certainly all of the family members felt that they were speaking on JP's behalf. It's very clear that everyone who was participating in that hearing loved him very deeply and felt that they were saying what they thought he would want in that scenario. The views of the children and of his brother were, I think, informed by having much more regular contact with him than some of the other family members had. But he also did regularly speak to his mother and his sisters, and he had close relationships with all of these people. And for them, they felt that his faith was the most significant part of his life. So I think certainly what they would say in this is that they were speaking in his voice and in what he wanted. And I think the difficulty in this scenario is that you have two sets of family members who are saying different things to each other, both of whom are saying, no, this is what this person was like, and this is what they would have wanted. What Mr. Justice Hayden said in the case specifically was that the family are not making the best interest decision, nor are they being consulted as to what they think is best. He said their observations are solicited to illuminate what JP's past and present wishes and feelings have been where ascertainable, and the beliefs and values that would be likely to influence his decision if he had retained capacity. The whole inquiry is focused on the protected party and engineered to promote autonomy for those who have lost capacity. For that reason, it is important to set out the relevant provisions in full, and he considered Section 4 of the Mental Capacity Act. And what he said is that he emphasized that my submission was that all of their views are relevant is not accurate. What is required is their views as to what JP would have wanted. Further, for the reasons that I have analyzed below, the preponderant evidence pointed very strongly as to where JP's best interests lay. The fact that there is disagreement among some family members does not absolve the ICB from their responsibility to evaluate the quality of the evidence, though there will be circumstances where the protected party's views will simply not be ascertainable from the evidence of family, friends, colleagues, etc. The case law, the Court of Protection, show these to be perhaps surprisingly rare. Now, it is certainly correct that families' views of a person are not determinative of their best interests. Section 4 of the Mental Capacity Act sets out a whole process in order for a decision maker to make decisions on behalf of the person. However, I would say that what Mr. Justice Hayden said here is somewhat controversial, as the plain text of the Mental Capacity Act does not say specifically what is indicated by the court here. And these were the submissions of my party in this case. What Section 4.7 of the Mental Capacity Act says that a decision maker must take into account the views of anyone engaged in caring for a person or interested in his welfare. Now, just to give a really common example of the sorts of decisions that are often made under the Mental Capacity Act, because this is all the same framework, whether you're talking about withdrawal treatment or whether you're talking about any other best interest decision in a person's life. If you're holding a best interest meeting to decide where an elderly person should live, it's entirely right that you should ask for the views of, say, the daughter of that person who is looking after their elderly relative. Where do you think this person should live? What do you think is in their best interest? The purpose of that exercise is not solely to figure out the perspective of P in that case. It's also to elicit views from those individuals as to what would be best for the person. So obviously I take on board what the judge has said. I've quoted to you what the judge has said in this case, but I think it is actually really important to look at Section 4.7 of the Mental Capacity Act, because for two primary reasons in this is one, both sides of the family felt they were speaking on behalf of P. And I think there is a real question as to whether there was such a minority view in this case that it should have been disregarded. What I would say is we had at least 7 or 8 members of the family, including P's mother, and other people who had close relationships and spoke with him, who said, no, his religion would have guided his decision, and that is what he would have wanted, and that's making a decision from his perspective. But beyond that, these are people who are interested in the person's welfare, and they are entitled to their own opinion, even if that's not necessarily a cipher for what P would have wanted in that case.
So essentially, I mean, we have seen, haven't we, a range of decisions in recent times where the judges have been anxious to move away from, the role of the family isn't to say what they want to happen, but more what they think P would have wanted to happen. But I suppose your argument in this case, Arianna, is that actually you'd heard divergent views from family members, all of which were saying this is what P would have wanted to happen. Well, JP would have wanted to happen.
And which is very common in these sorts of cases. I mean, I think, overwhelmingly, when you're talking to people who want to come and advocate on behalf of a person in the court of protection, these are people who love this person, care about this person. I think most people who come into the court of protection in these sorts of scenarios very much feel that they are there to be P's voice. Um, and they see it through their own experiences. They see it through their own relationship with P. I mean, certainly in this case, one of the things that was pretty consistent throughout was family members saying that JP regularly spoke with his mother about religious matters and would have followed her lead in religious matters. And that was a shared view across family members. And so, certainly from her perspective, in her relationship with JP, she saw a religious man, someone who cared very much about his faith. Whereas with other family members, his relationship wasn't as focused on that and it wasn't as grounded on that, and he wouldn't have spoken to him as much about those sorts of things. So I think it's all to say you can have many people coming to court in entirely good faith and giving entirely truthful evidence about what they would see about P, and really profoundly believing that they're trying to speak on behalf of P, but not coming to the same conclusion. And I think, from my perspective, this is one of the roles of the court of protection, is to try to resolve those sorts of disputes. And I don't know that it's necessarily right for a healthcare body to say, well, we're just going to ignore the evidence of all of these family members because they've got it wrong. I think if you had certainly an extreme scenario of someone who was very uninvolved with P, seemed to be saying something totally different from what the rest of the family was saying, seemed to be an obvious minority view that had no real forensic value in the best interest process, I think that, obviously a compelling case for that. What I would say is, in JP's case, I just don't really think that was the case. I don't think it was so obvious that one side of the family had it totally wrong that it would have been appropriate for the healthcare bodies to simply ignore that and withdraw life-sustaining treatment without bringing that to the COP.
So, Arianna, turning away from the case itself and looking at the wider implications, in practical terms, what systems do you think ICBs and NHS trusts should have in place to spot early on when a case should go to the Court of Protection?
I think with a lot of these prolonged disorder of consciousness cases, I think there is a growing awareness after this spate of court cases in the last few months that there needs to be an active consideration of best interest rather than just a default in terms of a person who has been put on to artificial nutrition and hydration, made no recovery, and things just keep ticking over for the person without anybody actually coming back and thinking, does this still make sense? Because, obviously for someone who's had a severe brain injury or hypoxic brain injury in this case, you don't go too fast on any of these sorts of things. And when you're making diagnostic criteria, you need to let the person have time to recover and have a person try to progress and see if there is any recovery to be had. But I think one of the things that this case highlighted was the dangers of just going on autopilot in this whole scenario. So I think one of the things that the ICB looked at, and we filed some feedback on this in our submissions around delay, was that there was going to be a review undertaken within the ICB in terms of spotting these cases, particularly for people who are on continuing care. Certainly for RHND at the hospital, they had a full internal program to review all of these cases and actually consider them. And I think one of the interesting things from RHND's experience was their apparent finding that the vast majority of these cases were actually amenable to having a best interest decision being taken without going to the Court of Protection, because once people actually reflected on it, there was actually agreement on the way forward. It was only in a really narrow subset of cases where they couldn't actually reach agreement. But I think for these cases of people who are in prolonged disorders of consciousness, who are on artificial nutrition and hydration, keeping them under review after many of the more critical incidents have passed, I think is one of the key findings of this case and GU and some of the other cases that were looked at, in terms of, is there a prospect of recovery? Is this now the steady state of the person's life? And would the person want to continue with this course of treatment on an indefinite basis if there is no real prospect of recovery?
Would it be fair to say, feel free to disagree, that the culture that we seem to have seen surrounding this case and earlier cases might have been more reactive or consensus driven than might ideally have been the case?
I'm not necessarily sure that it was reactively consensus driven. I mean, I think, I didn't represent RHD in this, and I think when hearing from their evidence, and particularly hearing from their evidence that of the 70 cases they identified, there were only 7 of them that had resulted in COP referrals. I think probably one of the things that does emerge from that, and I think one of the things that the court doesn't see, is that there are quite a lot of cases where people can, with discussion and best interest meetings and thinking these things through, agree and avoid a court process, which, in normal circumstances, that's going to be better for everybody if you actually have a consensus between family and medical professionals about what the right way is for the person. I think there are very few families that find the process of going to court anything other than difficult and stressful and not really something that they would want to have if it can be avoided. So I think that's one factor. I think the fact that there was a full year of a process probably does indicate that it might have been possible to spot sooner that this was not going to be one of those cases that a consensus was going to be found in. And I think there probably could have been an earlier cutoff point where people just said, we have made an effort to reach consensus, but we are not going to get there. And that's the point when it needs to go to COP.
So that's a sort of professional judgment sort of matter, isn't it? Is there any advice you can give, any thoughts you might have as to help to, if you like, increase the confidence of professionals to get the matter into the court?
Yeah, and well, and I think that the couple of things I would say on this are, this is very much an art rather than a science on these factors, because again, I think one thing that people who practice in this area will often say is once it starts going before the court, temperatures often rise. It often becomes more stressful, and the potentially consensual way forward is pretty much gone at the point that you do that. So I think this is something in the give and take in terms of the court asking, why didn't you get there sooner? The cases the court isn't seeing are the ones where actually people did get to yes, and the court didn't need to be involved in the first place. What I would say in terms of professionals having confidence about this is that usually in these sorts of withdrawal treatment cases, the medical evidence is very often overwhelming. I have not really seen many cases in which a problem with the evidence has been that the medical professionals went too soon in terms of bringing these things to the court. I think the medical evidence is overwhelmingly in cases where the person has been given every realistic opportunity to improve and get better. And the evidence is now clear that there is no prospect of recovery and the treatment is burdensome. A very standard configuration of these cases are family members taking the view that P would wish to remain alive. With some exceptions, and actually interestingly, there was one just reported this week of treatment not being withdrawn. But overwhelmingly in the reported cases on withdrawal of treatment for adults in prolonged disorders of consciousness, the court follows the medical evidence and withdraws treatment in accordance with the palliative care plan. The evidence, again, often being presented and often taking the form that the treatment is extremely burdensome. A person may be on ventilation or artificial treatment, which is, again, not going to lead into any recovery. And there is a certain futility about it. Some cases do go in different directions based on what the person would have wanted. And if there is really overwhelming evidence that a person would have wanted to live in this condition, I think with the case being reported just this week, this person being a highly spiritual person who very much believed in the healing power of the mind, being an example of one where the court said, well, actually, if we look at best interest from the lens of this person, that may be what they wanted. Now, JP, I think, is in many ways a more typical person. He was somebody who the idea of being in a permanent vegetative state was adamantly not what he wanted. One of his sons gave some evidence that JP had been a huge fan of comics and superheroes, particularly Marvel, and that he used to talk about how he would never want to be Professor X and he would want to be Wolverine, and he wouldn't want to be Professor X, even though Professor X had much better powers, because Professor X had to be in a wheelchair, and he would never want to trade even really great superpowers if he had to be in a wheelchair. And I think most people don't want to be in a vegetative state. And I think that is often how the evidence comes out. But again, it is always individual. And that is one of the reasons why it's important to talk to people's families and get a rounded sense of the individual in terms of who they are and what they want, because best interest is always through the lens of the person that you're making the decision for, rather than any sort of general standard. What I would say for professionals on this is there is really strong judicial encouragement, certainly in this case, from Mrs. Justice Tice from NGU, to say that it's right to bring these cases to the court if they're difficult or finely balanced. And the criticism is more likely on the basis of bringing them too late than too early.
Just to perhaps help some of our listeners, Arianna, with the Professor X and Wolverine reference. Professor Xavier was, of course, wheelchair bound, and Wolverine basically was more or less indestructible. So yeah, just to help anybody who's struggling with those references. So thank you.
But I think it was interesting because it was actually such a clear lens in terms of who JP was, because what everyone talked about his family was that he was a fitness fanatic. He was always cycling. He was always gardening. He was always in his home gym. He was just somebody who couldn't sit still, for even a second. And I think it was one of those examples that I think really was quite compelling to the court, and they included in the judgment in terms of saying this is who JP is. And when we're looking at things from his perspective is this incredibly active person who has now been bedbound and essentially unconscious for 9 years. And this is it. And I think this is one of the reasons why Mr. Justice Hayden in this case reached such a strong conclusion of saying that it was just entirely anathema to his best interest to keep him going in that situation when who he was just such an active person who would never have wanted to be like this.
You have several times during our conversation mentioned and indeed emphasized the need for a formal, well-reasoned best interest decision. That's, of course, something the judge mentioned as well. In your eyes, the court's eyes, what should be included in such a decision?
So there was a case from 2017, case of PL and the Sutton Clinical Commissioning Group. This is 2017 England and Wales Court of Protection Decisions 22. This was a decision of Mr. Justice Cobb. It set out a really clear framework for this, and I think it's a terrific starting point. Any best interest decision, again, it's specific to the individual in terms of what's being taken into account. But the PL case set out 3 overarching questions of what is PL's current condition, what is the person's level of consciousness or cognizance, what is their awareness of the world around them. Or second overarching is, does PL have mental capacity to make decisions about continuance of artificial nutrition and hydration? And is there a prospect they could develop that capacity? And if they lack capacity, is it in their best interest that you should be confirmed the continuing delivery of that? Now, in looking at that last question, is it in the person's best interest to continue on artificial nutrition and hydration? The court in that case looked at their previous stated views on life support, on sustaining life artificially, in the event that they were totally dependent on others and incapable of functioning in many essential domains of their life, the person's quality of life and whether they can enjoy anything, whether they experience pain or distress, their prognosis if artificial nutrition and hydration were to continue, and whether there's any prospect of recovery of functions, the prognosis if artificial nutrition and hydration were continued and a palliative care package were implemented, the prognosis of continuance of nutrition, but not, of hydration, but not nutrition, the views, wishes, and feelings of family and carers, the person's dignity, and the sanctity of life generally. Again, I would strongly recommend the PL and Sutton Clinical Commissioning Group because it's got a very nice sort of checklist in these cases, which I think cover a lot of the really central aspects. And I think if you have to boil it down, is the medical evidence in terms of the person's quality of life, prospect of recovery, whether they have any experience of the world around them or pain, and then the evidence around what the person would want in this situation, being the 2 sort of overarching heads that you'd want to be looking at for best interest.
Now, on a more practical, pragmatic level, of course, quite a lot of health professionals do struggle to deal with these family disputes. So even you know, where both cases, both arguments are quite evenly matched, perhaps especially where both cases and both arguments are evenly matched. Do you have any advice for professionals, any professionals out there at the moment who are caught in the middle of such disputes?
The first thing I'd say is it's not the job of the hospital to broker agreement. And if there is a case where it is really finely balanced and it's not really clear, this is why we have a court of protection, is to make these decisions. There is nothing wrong. There is no defeat in bringing a really difficult, complicated case before the court of protection. And that is probably the right scenario if you do have it that evenly balanced. Uh, what I think often brings cases before the court of protection is not necessarily two evenly balanced strands from the family, but what is very common is an overwhelming medical picture, which is, from the family's perspective, contrary to what the person would have wanted. When I talk to doctors and experts who have been in these scenarios and have been in these meetings, I think one of the things that they come back to, what they tell me works and is helpful, is to just aggressively listen as much as possible, and for the family to have as much time as possible to put across their views. I think very often in these scenarios, there are these meetings organized in which the purpose is to explain the medical position to the family, which I entirely understand. And I know why these meetings are organized, because people want to make sure that the family does understand what the medical position is. But often where these things get stuck is that the family doesn't really think that the medical professionals understand their perspective, and they don't think they really understand the person. And they feel that people aren't listening to them. And I think that's often where these sorts of things get stuck. And I think in terms of holding meetings where the family is allowed to speak uninterrupted and uncontradicted for really as long as possible before medical professionals start to come in, I think is really, really important. I mean, I've seen it in some of the cases as well, sort of similar cases of withdrawal treatment or ceilings of treatment cases, where sometimes the experts come in to basically offer a second opinion and listen to family members for hours before they start going into any of the medical points. And then after they've, I think, gained some credibility with the family by actually hearing about the person, people who have been looking after these people for their whole lives, are actually giving them the deference of saying, an awful lot about this person, and I am willing to listen to it. I'm willing to listen to everything you have to say. I think sometimes the families are more willing to listen at that point if they actually feel like they've been heard. And I think sometimes I think you can start to get a more therapeutic alliance between the family and the healthcare professionals when the family has that feeling. I think second opinion doctors can also be really helpful. I've seen that be a real breakthrough in a lot of cases in terms of either independent experts or people from outside trusts coming in. Again, particularly if they've got a lot of time to spend with the family, talking them through things. Because again, I've seen things where the family has rejected what the treating hospital has said repeatedly, but actually a second opinion doctor who has spent a lot of time and walked them through it, they feel they can be able to accept. Because I think often family feel like, I can't give up on my family member, but actually now, having worked it all through with someone else, they're able to accept that because they feel that they have done everything they needed to do and given the person every chance they could feasibly have. Again, as I say, it's very much an art rather than the science, but I think making sure the family feels heard, making sure the family's questions are being answered, and then giving them the space and time to process that, I think, are often some of the best way forwards, I am told by the doctors who have these sorts of incredibly difficult conversations.
They are, of course, yes, incredibly difficult. And it's really, I think, isn't it, about soft skills? It's about validating opinions, and it's very much about, as you say, collaborating and working together, and not rushing into these things. So absolutely. Arianna, I think that's all we have time for today, but thank you very much indeed for joining us, and very, very grateful for your input. Thank you very much indeed.